All right, our next topic today is going to be Introduction to Federal Employment Discrimination Laws with laughs. I like that little addition there. You guys will probably get the impression today we're trying to do a balance of plaintiff and defendant's perspectives through the materials, as through all the topics. Both Josh Van Kampen, who's a partner at Van Kampen Law, and Nicole Haynes, who's an associate there, have a very interesting perspective. They're both plaintiff's attorneys, prominent in the field. You will come across these guys if you have been practicing employment for some time or if you will. They're both excellent attorneys with an abundance of knowledge to share with you today. But interestingly, they both have defense backgrounds before switching to the plaintiff side. So I think that provides a very unique perspective, and we're looking forward to the presentation today. So thank you.
Good morning. Okay, so we're going to go over the Introduction to Federal Employment Discrimination Laws for you today. And it just, as a brief overview, that means Title VII, which is our race, color, religion, sex, national origin claims. And then the ADA, the Americans with Disabilities Act, which is our disability protections. And then the ADEA, which is the Age Discrimination and Employment Act. The first part of any analysis for federal employment discrimination claims is how many employees were there. So Title VII and the ADA only cover workplaces that have 15 or more employees for each of the 20 or more weeks in the year before the claim is filed or the actions arose. Now, that's the most important because as a plaintiff's counsel, we certainly don't want to be in the position where there are only 13 or 14 employees and then our client doesn't have coverage because the jurisdiction is not there then. In the ADEA, the threshold is for 20 or more employees. Just as a related note, as Laura mentioned in her earlier presentation, the state of North Carolina has the Equal Employment Practices Act, and that covers, their term is handicap, as well as age claims and all of the other comparable Title VII claims, and their state employee threshold is also 15. So more than one entity may be aggregated under certain circumstances to create an integrated enterprise. So if we have folks come in who maybe have 8 to 10 people working with them, but their business and another business are controlled by the same employer, then we may be able to loop them all together to reach that 15 or 20 person threshold. The other jurisdictional prerequisite is that the businesses affect commerce. It sort of goes hand in hand with the employee threshold. Courts have determined that if they meet those 15 or 20 employee thresholds, that there is enough affecting commerce, and it's virtually any employer affects commerce. So the coverage of the federal discrimination laws depends on the employees. The Walters versus Metropolitan Educational Enterprises case was a Supreme Court case in 1997, and there was a circuit split the Supreme Court addressed on how to count the number of employees. The debate was whether or not we look to daily attendance to determine whether or not that employee threshold was made, or do we look at the number of employees on the payroll? The court decided that anyone who's on the payroll during a particular week, full-time or part-time, whether or not they worked, whether or not they were present, is counted towards that 15 or 20 employee threshold. So practically speaking, as a plaintiff side counsel, we want to look at who was on the payroll, who has a sufficient relationship with that employer to be counted as an employee. On the defense side, you would want to make sure that your payroll records or your client's payroll records are always updated so that you don't inadvertently cross an employee threshold that you didn't intend to. Just a side note on this, it's heart-wrenching sometimes when folks come in who don't have protection under the laws because their employer isn't large enough. So it's really important as practitioners, as you're vetting cases and deciding which cases to even meet with, you don't want to give false hopes to a potential client, so you want to make sure that in your initial vetting, you're looking at that employee threshold. So which employers are covered? Private employers, which covers a large majority of the employers in the United States. Labor organizations, so those are our unions, staffing agencies and contracting agencies, those businesses that source employees. State and local governments are of course covered, and then most federal employers are also covered. The labor unions and employment agencies have a unique position. For the first 4 years of my practice, I worked for a management side law firm that practiced traditional labor law. So I worked closely on the opposite side of unions, and I can certainly say that they do affect commerce in a significant way to qualify for coverage. Unions are liable under the federal employment laws to both their own employees that work for the labor union entity, as well as they could be liable if they attempt or cause to attempt an employer to discriminate throughout their collective bargaining and union representation. Employment agencies and staffing agencies, so there's an interesting dynamic there where two employers may employ the same employee. So the staffing agency is doing the initial interviews, they're hiring the employees, they might be the entity on that employee's paycheck, but they're sourcing those employees to a third-party employer who manages the day-to-day and supervisory responsibilities and the right to hire and fire that employee. So you can see how there might be an issue, well, which employer are we looking at for the purpose of that 15 or 20 employee threshold? And the courts have said that they may be combined to reach that threshold. The Fourth Circuit has an 11-factor hybrid test that looks at the degree of control exerted as well as the economic reality of those situations. The founding case for that is Butler versus Drive Automotive. The site is 793 F3D 404. That's out of the Fourth Circuit in 2015. So those 11 factors are supervision, skill, who provides the equipment, the duration of the employment, method of payment, the work relationship at the time of termination, whether or not annual leave was provided, whether or not retirement benefits were provided, whether or not the employee's work was integral to the employer's business, whether or not Social Security taxes were paid, and of course, the catch-all, what was the intent of the parties. So as I mentioned, it can be heart-wrenching on plaintiff side when an employee works for a place that doesn't have that 15 or 20 employee threshold, but it is essentially a get-out-of-jail-free card for employers where they are able to sort of carte blanche discriminate against whoever they want, whenever they want, and there may not be repercussions for them because there is that hole in the law. For exceptions, the employers who are not covered by these federal employment discrimination laws are Indian tribes, bona fide private clubs, religious corporations and associations where membership in a particular religion is required to perform the connected duties. And that requirement language is important because if it's not required that they be of a certain religion to perform their duties, then that entity could still be covered. There's another interesting hook if you are a corporation or represent a corporation who employs folks overseas. So if you're a United States corporation and you have a business overseas and you're employing aliens, then these federal employment discrimination laws do not cover that situation. If you're a United States corporation and you're employing Americans overseas, then you do have the responsibility to conform with these federal employment discrimination laws.
All right, hi everybody. So what I'm going to do next is cover the bread and butter claims. So there are some claims that are more obscure that I just don't think are worthwhile to cover, but we're going to cover the bread and butter claims together. The first of those are disparate treatment cases. So disparate treatment basically means that there is a double standard that is being applied by an employer. So what do we have to prove in a disparate treatment situation? we have to prove that an employer took a discriminatory action because of our client's protected category. So what does because of mean? Because of means basically anything, Because of, it doesn't have to be the only reason. It doesn't have to be the sole reason. It only has to be a contributing factor, essentially, an important enough factor to tip the scale in favor of a termination decision. So my management side friends will oftentimes try to get a jury to buy into the fact that this has to be the main reason or the only reason, and that's actually not the case. Okay, so next we're going to talk about the burden shifting model. So the burden shifting model is McDonnell Douglas. So for my colleagues that are in the audience regarding the plaintiffs, we don't want to refer to the burden shifting model when we're before a jury. The burden shifting model is only applicable essentially when we're arguing summary judgment. Now there are 4 factors in the burden shifting model. The first is protected class. So with protected class, that covers race, color, sex, religion, and age. And it may also cover sexual orientation. That's actually debatable right now. The Supreme Court, we're very nervous as plaintiffs' attorneys. The state of the law in the land now is sexual orientation is a protected category, but the Supreme Court, and with Justice Kavanaugh now added to the bench, is about to rule on that this year. So we have our fingers crossed and actually are pretty nervous about what's going to happen with that. But first of all, we have to show that our client is in a protected class. Next, we have to show an adverse employment action. So think about a federal judge. She is a busy judge. Don't come in here about something that's minor. It has to be something involving, for example, a termination or a demotion or a transfer where there's a substantial reduction in responsibilities, for example. That can qualify. But it has to be a big enough deal where the judge isn't going to be mad at us for bringing it. Third, we also have to establish that our client is qualified for the position or basically can perform the legitimate job expectation. So they can't be horrible at their job, in other words. And then the fourth factor is called other evidence of discrimination. So with other evidence of discrimination, that's basically you can show that by, for example, showing that there was somebody outside the protected class who was retained. We can show that through discriminatory comments. We can throw it in any number of ways. But what you need to understand coming out of here today is this prima facie burden is easy. It's not onerous. It is viewed as de minimis. So my management side colleagues are going to try to erect the prima facie standard as some massive barrier that we need to get over. But in truth, that's not the way the Supreme Court intended it to work. So once we have established our non-onerous burden, it flips over to the employer. So what does the employer have to do? The employer has to come forth with a legitimate, non-discriminatory reason. So I tried to get a little creative to illustrate how easy this is. So an employer could come forth and say that they basically have voices in their heads, and the voices say that they should have fired our employee because of X, Y, Z reason, and that would be enough. I've got the ham sandwich up here to illustrate the point. You've heard about how a district attorney can convict a ham sandwich with a grand jury. Same thing goes with legitimate non-discriminatory reason. The judge will just accept whatever reason the employer puts out there. So then at that point, the burden switches back to the plaintiff to show something called pretext. And basically what we have to do is convince a judge or a jury that the employer's reason for the termination was not the real reason, or was false, or was not believable. And let me play this video to illustrate the point.
15 minutes could save you 15% or more on car insurance. Everybody knows that.
Well, did you know Pinocchio was a bad motivational speaker?
I look around this room and I see nothing but untapped potential. You have potential. You have... Oh boy.
Geico. 15 minutes could save you 15% or more on car insurance.
So if we can establish essentially that the employer is not being honest about the reason for the termination, that's how you show pretext. So obviously, I wish it was like Pinocchio and the nose just grows, but there are lots of ways to establish a pretext. So let me run you through some of those. All right, so the first is shifting reasons for termination. So basically that means they're changing their stories. And I would say probably about half of our cases, we are able to establish that the employer has shifted reasons for termination. So you start first with the termination meeting. So my management side counsel are usually telling their clients, don't tell them why you're fired, because that's the first articulation of the termination that we're going to now try to contradict or rebut. But most of the time, a reason for termination is going to be given in the termination meeting. So let's start with that. And then let's compare what the contemporaneous emails show. So usually the contemporaneous emails, once you get a hold of them, describe a different reason for a termination than what was described in the termination meeting. So, whoops. So you've got two conflicting stories. And then after the employer files an EEOC position statement, they're going to articulate now to the EEOC, this is why we fired the person. That's 3. And then eventually we're going to get to a deposition. And you know what my objective is, try to get the witnesses, different decision makers to tell different stories. And so it's not uncommon in cases like this where you have maybe 3 different articulations for a reason for a termination. That is the equivalent of Pinocchio's nose growing. Another thing we like to see for pretext evidence is, you got a rock star employee with 20 years of, positive evaluations, and then all of a sudden they can't walk and chew gum right at the same time, and they've got a new, younger manager, for example. That's boilerplate pretext evidence. And then we definitely love the rush to termination. So management counsel will tell their clients, whoa, slow it down on your way to a termination, follow the progressive discipline steps, because we don't want to look like we didn't give the employee a chance to improve. I hate when their clients listen to them. It makes my job harder, but when they do rush to termination, that's a good pretext evidence piece. And then also departures from standard procedures. So let's say the company policy is have a human resources rep present when you're terminating an employee, but then with our client, they didn't have the HR rep present as a witness. Whoops, that's a deviation from a standard procedure, and that can make us think that Pinocchio's nose is growing. And then, of course, timing. Close timing to, for example, an internal complaint of discrimination and a termination, as judges really like that. So that is what you call the circumstantial evidence model. And then you have, in a rare case, would be direct evidence. So let me play an old video that y'all are familiar with.
Either way, I don't give a damn what you think you are entitled to.
Did you order the code red?
I did the job. Did you order the code red? You're goddamn right I did.
So that's definitely direct evidence. And that never happens. So, I would say in 90% of the cases we bring, we don't have any sort of admission. I've had one case, and I'll tell you about that one, that I think will help illustrate the point against a bank in Charlotte. So in that case, I represented a client who was in a wheelchair and quadriplegic. And he was a rock star for many years, but got a new manager, and she selected him for a job elimination. And she told him in the meeting, quote, I think you would be better off in a less demanding position, like a business analyst position. That's not quite as dramatic as what you saw there, but ironically, the EEOC didn't think that this was a meritorious case. But when we filed it in the Western District, Judge Howell in Asheville determined that that was actually direct evidence of a discriminatory motive toward my client who was in a wheelchair. All right, so next, mixed motives. Now, we all tell our children stay away from vans. Certainly vans that say free candy. I have put this up here so that everybody who is a plaintiff's attorney in town or a potential one understands, don't do this. Mixed motive cases, it actually sounds nice because your evidentiary showing is less in terms of what you need to prove. You only have to establish that the reason for the termination or the protected category rather was a motivating factor. That's easier than saying because of. The problem is that comes with a huge string attached. That huge string attached is that you forfeit your ability to recover any sort of money damages. So, we're not in it to get attorney's fees in a case. We're in it to, get our client compensated for something bad that happened to them. So why in the world would we want to proceed under a proof scheme that makes it where our clients can't recover monetary damages? So this is a trap for the unwary plaintiff's attorney. You want to stay away from that. Then the other thing is juries get confused by the mixed motive cases. I would have a hard time teaching it to you if it was useful. So for all those reasons, stay away. The employer attorneys, sometimes they'll try to get a jury instruction about mixed motive, and we're like, no. We don't want that. We're not arguing that for that reason.
All right, so just to touch on the types of claims for harassment or hostile work environment. Title VII prohibits harassment based on any of the protected traits, so race, religion, national origin, color. But the most common and most publicized form is going to be the sexual harassment, so we will use that to sort of examine the framework. Of course, the ADEA and the ADA also prohibit harassment based on age and disability, respectively. As Josh mentioned with the first part of that prima facie case, the employee needs to be a member of a protected class. He also briefly touched on the definition of sex as a protected class under Title VII and said that the Supreme Court will be deciding that. It's in the manuscript materials, but on October 8th, the Supreme Court heard 3 cases at the same time on oral argument that will determine the definition of sex under Title VII. Out of the Second Circuit, there was Zarda versus Altitude Express. In that case, a gay man was a skydiving instructor and made a comment to a female patron, don't worry about being strapped to me. They were tandem diving because I'm gay, so I'm not going to harass you or, cop a feel. And he was terminated for that comment. So the Second Circuit decided, yes, Title VII protects folks' sexual orientation within the definition of sex. And then another case that reached the opposite result was out of the 11th Circuit. That's Bostock versus Clayton County, Georgia. A long-term employee joined a gay softball league and was later terminated. The 11th Circuit had some bad existing circuit court precedent, so the district court applied that precedent and said, no, sexual orientation isn't protected in the 11th Circuit, and then the 11th Circuit Court of Appeals affirmed per curiam. The tone of those opinions is a little bit regretful, where maybe had that precedent not existed, it also wasn't an en banc court on the 11th Circuit that affirmed that. So you can sort of hear some regret when you read those opinions. The last case that the Supreme Court heard on October 8th at oral argument was the EEOC versus Harris Funeral Homes. And that's out of the 6th Circuit, where a employee is a transgender woman and notified her employer that she would be presenting as a woman at work. and was then terminated. The Sixth Circuit also determined that, yes, the transgender status is protected within the definition of sex in Title VII. So those were heard before the Supreme Court. We expect a decision to be issued sometime in June on whether or not, on the basis of sex within Title VII includes sexual orientation and transgender status individuals. So as we're talking about, different types of harassment and what you can and can't do at work, here's a little video illustration.
The most fundamental thing about sensitivity training is that you cannot make fun of a person for something or some action that they have done that they regret. You can only make fun of things that they have control over. Like Oscar is gay. That is his choice. We can make fun of that. I did not choose to fall into a koi pond.
Maya, you still can't make fun of people for race or gender or sexual orientation or religion.
Who let the lemon head into the room? You are a waste of life and you should give up.
And we can see the problems there. So with a sexual harassment framework, there are two types of sexual harassment. One's the quid pro quo, which is more rare, but might be sort of the you scratch my back and I'll scratch yours arrangement, typical of those sorts of harassment. With that sort of harassment is that there be a supervisor and subordinate relationship where one party sort of has control and leverage over the other. And then the hostile work environment based on sexual harassment. So to establish a hostile work environment, the conduct has to be because of sex. The conduct has to be severe and pervasive, unwelcome, and there also has to be a basis for employer liability. And we'll get into all of those in turn. Conduct that is because of sex. This includes sexual advances, touching, hostility towards a gender, but not necessarily of a sexual nature. So because of sex or on the basis of sex doesn't mean that it has to be sexual. And then sexually offensive language, visuals, gestures, and that sort of conduct. Same-sex harassment, now I don't mean same-sex as in sexual orientation here, but same-sex as in a male supervisor harassing a male employee or a female harassing a female employee. So same-sex harassment is recognized under Title VII as long as it, again, is because of someone's sex. The issue of an equal opportunity harasser, we substitute the word harasser for something different that I can't say right now in our office, but if someone is an equal opportunity harasser and they are an equal opportunity abuser and this manager is just horrible and malignant, but they are horrible and malignant and abusive to everybody in the workplace regardless of their protected class, that's not going to be protected by any of these federal discrimination laws. So it would have to be targeted based on one of those protected classes. Conduct that is severe or pervasive, it's a very factually intensive inquiry. Both severe and pervasive have to be considered together. Factors that the courts will consider are the frequency and severity of the conduct. Was it physically threatening or humiliating? Did it involve physical touching? Was it just an offensive statement? Did it unreasonably interfere with an employee's work performance? What was the general tone of the workplace? Was it an auto mechanic shop where they have the pinup calendars and everyone's a little bit crass? If so, was it severe and pervasive within the context of that work environment? It's an objective and subjective standard. So that means that objectively, the conduct has to be sufficiently severe and pervasive such that it creates a work environment that a reasonable person would consider intimidating, hostile, and abusive. At the same time, it has to be subjectively severe and pervasive, which means that it alters the working conditions and that the employee was actually affected by it. You can't have, sometimes we have folks who come in and they're like, yeah, I think this is weird. This happened, this manager said this, but it didn't really bother me. Well, it has to be subjectively severe and pervasive as well. A companion with what gets the most publicity right now is the hashtag #MeToo movement. A lot of times, and we've noticed an influx of calls at our office with the Me Too movement because something that might be gross or, just a little bit smarmy, or it kind of raises the hair on the back of your neck, might not rise to the level of severe and pervasive actionable sexual harassment conduct. So just because you might be able to hashtag Me Too, and that's legitimate concern, and it really happened to you, doesn't mean that it's legally actionable. Conduct that is unwelcome. Again, numerous factors. There are all these multiple factor tests riddled all over these analyses. The friendliness with the harasser, the failure to report harassment. Did they remain in silence? Did they let it go on for years? Why didn't they report it? Willing participation in sexual conduct. Did the individuals have some sort of sexual relationship? The employee's solicitation of the harasser's attention, such as overly provocative dress. We can debate the merits of whether these things should be considered. The fact is they are considered. Prior consent, although prior consent is not determinative. The sexual harassment analysis is different from the analysis for other types of protected classes, like race, national origin, etc., where conduct on the basis of those classes is assumed to be inherently unwelcome, whereas conduct on the basis of sex for sexual harassment claims is not automatically inherently unwelcome. As I mentioned earlier, there also has to be the basis for employer liability. So we've got first, because of sex, it has to be sufficiently severe and pervasive. It also has to be unwelcome, and then there has to be some basis for the employer liability. So it requires answers to the following questions. Who committed the harassment? Was it the CEO? Was it a mid-level manager? Was it a coworker? Was it a third-party vendor who stocks the Coke machine? Was it a delivery driver? Was it the postal worker who comes into the office every day and interacts with this employee? Who was the harasser? Did the harassment result in a tangible employment action? So what was the effect of the harassment? Did the individual get demoted? Did they get fired? Was their pay decreased? Did they get relocated? And then what was the employer's response to the harassment? Did the employee sort of run it up the chain? Did they make any complaints? If so, was there an investigation? How did the employer respond? How were all of the parties notified of the employer's decision, etc.? This analysis for employer liability applies whether or not the harassment is the quid pro quo or hostile work environment.
You can't triple stamp another stamp. You can't triple stamp another stamp, Lord. You can't triple stamp another stamp. Lord, you got...
This is maybe a not so friendly opinion of what our management side attorneys might deal with their clients, employers who would rather stick their head in the sand, stick their fingers in their ear, and not listen to what's going on or claim to be oblivious of what's going on. So if a harasser is a supervisor, a tangible employment action resulted, the employer will be liable. If the harasser is the employee's supervisor and the tangible employment action did not occur, then the employer may avoid liability by establishing an affirmative defense. So as management side counsel, I responded to a lot of EEOC position statements. And almost all of those position statements, the employee had not been terminated. They were still an active employee. And in every single one of those position statements, I asserted the Faragher Ellerth affirmative defense. So what is that? An employer has to use reasonable care to prevent and promptly correct behavior that could be considered sexual harassment. So if they've done that and the employee unreasonably failed or refused to use the employer's procedures for preventing or addressing that harassment. So what does that mean? It's pretty language. What it means is an employer, to be able to assert this affirmative defense, the employer has to have some sort of policy or reporting procedure in place. Where do we find that? In the employee handbook or in a standalone policy. If the employee unreasonably failed and it can be debatable, but if an employee has their signed handbook acknowledgement form and they didn't follow that procedure, then the employer may be able to assert this defense because the employee unreasonably failed to follow the procedure set out by the employer. Therefore, the employer had no opportunity to remedy the conduct, hence their defense against liability. And those situations were for supervisor or someone above the employee being the harasser. For liability, if the harasser is a coworker, and I believe this is also the same standard for third parties, then a negligence standard that the employer knew or should have known that the harassment was occurring will apply for the employer liability analysis.
Okay, next bread and butter claim to cover are disparate impact claims. So remember before we were talking about disparate treatment, well, that involves intentional discrimination. Disparate impact, we don't need to show an intentional discrimination. Essentially what we're establishing is that regardless of intent, there was some sort of policy in place that had a disproportionate impact on somebody in a protected group. So what do we have to do first? First, employees have the burden of proof and persuasion to show that a facially neutral employment practice had a disparate impact. Understand, if you're going to go to war on a disparate impact claim, you need to have an expert to talk about those numbers. Because, essentially there's going to be a battle of experts in any sort of disparate impact case. And if you're thinking about it as a plaintiff's attorney, you have to make sure you have the resources to hire an expert. That said, it doesn't cost you anything to allege a disparate impact claim in your EEOC charge. And in fact, if you want to keep the door open to bring a disparate impact claim later when you get to court, you actually have to include it, or you should, in your EEOC charge. Plus, it makes my management side friends a little nervous, where they're worried that this could have a broader impact, not just with our plaintiff, but a larger component of the organization, and they might want to settle. But assuming that the plaintiff can establish a disparate impact of a neutral employment practice, the burden then shifts to the employer to show that the challenged practices are job-related or have manifest relationships to the job. So in other words, they have to say, well, there's a reason why we have this standard, essentially, a business reason, job-related reason. And then it comes back on us to establish that there was a different standard that could have been applied that would not have had a disparate impact. And really, you need an expert to establish what this other standard would be. So, careful about bringing those in court unless you have the resources, but allege that in your EEOC charges for sure. All right, the next type of claim are retaliation claims. So these are our favorite type of claims. In fact, there have been some studies to look at success rates involving discrimination cases versus retaliation cases, and retaliation cases success rates for plaintiffs are higher. So you want to bring retaliation claims if you can. So what employees are protected from being retaliated against depending on what they're complaining about. So understand that the protections from retaliation, they arrive or basically are offshoots of discrimination statutes. So in order for you to be protected from retaliation under a discrimination statute, you have to allege discrimination. You can't be complaining about unfair treatment, my boss doesn't like me, my boss has a personality conflict. If you're not tying that complaint to discrimination, you're not under that discrimination statute to begin with. And so I always tell my clients, they're always so nervous. They're like, well, I don't want to make anybody mad. And I explain, you have got to ring the bell. You have to use the words, and you have to do it in a way that you can prove that you have made that internal complaint. So to illustrate the point, this is what you need to do. That's enough. You got to ring the bell. If your client doesn't ring the bell, they're not protected, period. Now, another way that an employee can be protected as well is if they've made, obviously if they've made a complaint, it can also be if they've assisted. So let's say there was a colleague who was a victim of sexual harassment and she complained to Human Resources. And now your client has been interviewed in the investigation and your client now is essentially giving testimony or a supportive account of that sexual harassment incident. That person who's being interviewed by Human Resources is participating in an investigation. It doesn't matter that the investigation's internal. Still an investigation, and that person would be protected. All right, and there's actually, we talked about Title VII, it prohibits sex discrimination. There's actually an amendment to that called the Pregnancy Discrimination Act that also prohibits discrimination against pregnant women. Now, I don't know what it is with employers, and I think Nicole's encountered this in her first year at the firm. We get a lot of pregnancy discrimination calls. It's almost like I think managers just think, oh, somebody's pregnant, they're not going to come back to work, or I really don't understand. But we get a lot of more blatant type calls on pregnancy discrimination for whatever reason. And here's another office clip since we promised you some laughs.
Yeah, that's right. It's a baby, see?
Sir, you can't smoke that in. Put it out.
Can't smoke anywhere these days.
No, and so obviously pregnancy discrimination is its own thing and prohibited. Now, another bread and butter claim are failure to accommodate claims. So I think later there's probably a presentation on the Americans with Disabilities Act, but putting that to the side, there are duties to reasonably accommodate under Title VII. One of those is for religious discrimination. So let's say you have an employer who is employing a Muslim, and obviously Muslims that are devout, pray multiple times a day. Well, that employer would have an obligation to, afford that employee the opportunity to pray. And same thing for Jews and the Sabbath, for example, and not being able to work on the Sabbath or to drive a car, for example. These are accommodations that are required on a religious basis. And then also, so for pregnancy discrimination, I was disturbed to learn that there isn't a duty to reasonably accommodate in the statute for pregnancy discrimination the way you have for the Americans with Disabilities Act. And I'm like, how do you not have that? The good news is that there is still a duty to accommodate pregnant women consistent with however they accommodate other folks. So you kind of like tie this back into the Americans with Disabilities Act. So let's say an employer had accommodated somebody with cancer and gave them 3 weeks off or light duty. That's required under the Americans with Disabilities Act. Pregnancy Discrimination Act doesn't have a reasonable accommodation standard in the statute, but you can't discriminate. And so that pregnant employee needs to be accommodated in the same fashion as someone was under the Americans with Disabilities Act. Okay, so the EEOC, not a big fan, but I'm just gonna leave it at that. I'm a big fan of some of the staff there. But so the EEOC is the federal agency that is in charge of enforcing the laws that we've talked about. So Nicole and I are what they call private attorney generals. We're incentivized to take these cases because of the fee shifting provision. But the EEOC is supposed to enforce these laws very vigorously. And that starts first with the investigation process. So understand, you have 180 days, or your client has 180 days from the date that they learned of a discriminatory act to file with the EEOC. 180 days from knowledge. So let me play you a video to illustrate this.
We're going to be getting rid of these people here. First, Mr. Samir Naga. Not going to work here anymore anyway. And Mr. Mike Bolton, I'm just going to miss him.
You're gonna lay off Samir and Michael.
Oh yeah, we're going to bring in some entry-level graduates, farm some work out to Singapore, it's usual deal.
Well, standard operating procedure. Do they know this yet?
No, no, of course not. We find it's always better to fire people on a Friday. Studies have statistically shown that there's less chance of an incident if you do it at the end of the week.
So that is literally true. People are fired more on Fridays. I think if you looked at our call intakes on the weekend and on a Monday, there's a clear spike. So remember there was the joke here about, oh no, they didn't know they were fired. Well, one trick that employers sometimes try to use is you inform an employee that they're being fired, and let's say you give them 30 days notice before their last day. So the unwitting plaintiff is going to focus on his last day as the 180-day point and say, oh, I wasn't fired until that 30th day. That's not how this statute works. The statute is going to count from the date you were on notice that your rights were going to be violated. So you're counting 180 days from knowledge of the adverse action. All right, so this Form 5, it's online. There are boxes for all the different protected categories. You have got to check the boxes. If you don't check the boxes and later you're trying to file a lawsuit and you don't check all the appropriate boxes, your management attorney is going to be arguing that you haven't exhausted your remedies. And they might have a point. So make sure that even if let's say you have a flagship claim, mostly you're focused on age, but you also might have a potential sex discrimination case to go along with it. Check whatever box that you think you might use later, because if you don't, you may foreclose that opportunity. So with the EEOC, you do not have to serve a copy of this EEOC charge on opposing counsel. The EEOC is going to send it to the company for you. I still send a courtesy copy to my management side friends, and then reminding them about the mediation program that the EEOC has. And so when an employer is notified of an EEOC charge, they're going to be given two options. One is to respond to the investigation, in other words, defend it. And the other is to participate in the EEOC's free mediation program. So we're always plugging to get these charges over to the EEOC program. So for my plaintiff side friends, send a copy of the charge, and nudge your defendant to participate in that. Now, just real fast on the EEOC investigation. There are some investigators that will dig. Unfortunately, most EEOC investigators don't. So you're going to file a charge. The company is going to be required to submit a position statement. And then at that point, the plaintiff is going to be given an opportunity to submit a rebuttal to the position statement. The EEOC has the right to essentially demand documentation. They have the right to conduct an on-site investigation and interview witnesses. They rarely use that power in practice, unfortunately. So when you're talking to your client about your expectations of the EEOC investigation, don't expect a lot, and then be pleasantly surprised if you get a more thorough investigation. Okay, you're up on that.
Just to follow up a little bit on that EEOC investigation process, once the EEOC finishes their investigation, they will issue a right to sue letter, and it either checks that they found cause or that no cause was found, but you still have the right to sue, and then that lawsuit should be filed within 90 days of when receipt of that right to sue letter occurs, and it can be filed to preserve those claims. But it is a quick turnaround within those 90 days. If the EEOC decides to pursue the case, they'll issue a notice of determination of a violation. They'll offer the parties to attend a conciliation process, which we've recently gone to with one of our clients, and then the EEOC will sometimes pursue those claims in court. So when you see cases where it's EEOC versus so-and-so in those federal captions. It's cases that the EEOC has found cause on and elected to pursue. And we are currently litigating one in the Western District where the EEOC is the plaintiff and our client is the intervener, and going through that three-party discovery process, which is very exciting. Okay, so this is the really exciting part, the dollars. What remedies are available? Under Title VII in the ADA, we have the equitable relief, which is the back pay and benefits plus interest, and then reinstatement or instatement, front pay, diminished earning capacity. Reputation damages can be compensatory. Also compensatory damages are emotional distress, pain and suffering. There are punitive and compensatory damage caps under Title VII in the ADA. There's also a provision in those statutes for attorney's fees to be awarded. Now, because at the heart of any claim, once it gets all the way through litigation, is going to be the dollars and cents. Once we determine liability, well, how much is that worth? The jury can determine that. It's important to have a damages expert, someone to really go through with a fine-tooth comb and determine what the damages were, and testify at the trial on that. Also, the plaintiff has the duty to mitigate their damages. So that's another, it's actually an affirmative defense that the defendant can assert, is that the plaintiff failed their duty to mitigate their damages. What that requires is that while the plaintiff is unemployed, that they fill out the job applications and try to obtain similar employment. And then, of course, that reduces the damages that the employer may be liable for. So there is the duty of the plaintiff to mitigate. It's an affirmative defense that the defendant has the burden to prove that the plaintiff did not satisfy their duty to mitigate. Well, it's supposed to be an affirmative defense. What it really means is that the plaintiff should always put forth evidence as to mitigation as well. Mentioned that there are statutory caps on Title VII and ADA claims. So there is no cap on back pay, benefits, or front pay, plus that interest, but there is a cap on the compensatory and punitive damages. It's based on the number of employees the employer has. So 15 to 100 employees, we've got 50 grand. 101 to 200 employees, $100,000, and then it goes all the way up to $300,000 for those employers that have over 500 employees. And then for the ADEA, the benefits are a little bit, well, actually, we're going to go back. So under Title VII, of course, covers the race, color, and national origin claims. If your client is eligible to assert a Section 1981 claim for the race discrimination, you always have to assert that because to prevent double recovery, you want to assert the Section 1981 claim because that's where your punitive damages are going to be. If you have Title VII and a Section 1981 claim, Title VII punitive damages no longer apply, and the Section 1981 punitive damages will be your sole remedy for that. It requires malice or reckless indifference. And under Section 1981, the punitive damages are not capped. So those are, in theory, available up and above the $300,000. Okay, so to the ADEA, these remedies are a little bit different. We've got back pay, benefits, and interest. That's our equitable damages, reinstatement or instatement, front pay. Instead of compensatory or punitive damages, so there are no emotional distress damages here, no punitive damages here, but the statute does provide for liquidated damages, an amount equal to the back pay and benefits, and then attorney's fees and costs as well. Do you have a follow-up?
We got a little time to kill.
Got 6 minutes, so y'all are going to have to help us out.
We can talk a little bit more about damages. So one of the things that we struggle with as plaintiffs' attorneys is, emotional distress damages and pain and suffering damages are recoverable under Title VII and the ADA. But how do you quantify it? And, you know, and we're always kind of struggling with this. And so in the plaintiff's deposition, you know, good opposing counsels are always asking, you know, well, what are you asking for? You know, what is it that you want a jury to award you for emotional distress damages? And we know they're going to ask those questions, and I would have a hard time, you know, answering it if I was the plaintiff. So we always coach our clients to say we're just going to respect whatever the jury decides is an appropriate figure for emotional distress damages. And I literally I got in a pretty heated argument with an opposing counsel in our case with the EEOC, where he just wouldn't accept that and badgered the witness for quite a while. But just understand there isn't a formula that you use for what you're asking for with emotional distress. But once you get to a jury, you got to ask for something. And we, to this day, kind of struggle with what to ask for with that. And then just sticking with damages. So in the case that Laura was talking about, our Driscoll case up on the Fourth Circuit appeal, we were very disturbed when we didn't receive any emotional distress damages from the jury in that case, but we got a whopper of a punitive damage award. And then we're, you know, questioning the job that we did as lawyers that, you know, the jury didn't award anything for emotional distress. And you know, an interesting component of that case was Judge Whitney gave us, we were on a shot clock. I don't remember how many hours we had on the record in that case, but I think it was around 12 or 13 hours or so for all our witnesses, and including opening and closing. And so we had to strategically pick what we hit on. Even in closing, we had to strategically decide what bells we wanted to ring with the jury. And we rang more punitive damages bells than we rang emotional distress bells. And even with our witnesses, it was never a great emotional distress case to begin with, but we had to speed through our emotional distress witnesses. And sure enough, it just goes to show you where you prioritize with a jury, the bells that you ring, the time that you spend, it converts into what they do, you know, especially with damages buckets. Then the other thing is, you know, we started pleading diminished earning capacity as a damage. So normally you're looking at future lost wages and calling it front pay. Front pay is something that the judge is going to decide as an equitable remedy. Normally we're like, we don't want that because we're thinking the jury is going to be more generous than a judge would be with front pay. But not if you're Geraldine Sumter. So Geraldine Sumter just had a jury trial victory this past year where Judge Mullen gave, I don't even know, hundreds of thousands of dollars in front pay. It was years and years and years of front pay. And I wouldn't expect a jury to have even been that generous. But so anyway, one of the reasons why we plead diminished earning capacity now is we were trying to have a category of damage to get to the same place where a jury could decide that issue potentially as opposed to a judge. But, you know, for my plaintiff's attorney friends, it's so easy to neglect the damages side of your case. We kind of did, you know, in that trial, made that mistake. But it's really important to be focusing on damages in these sorts of cases. All right, so now I think we're close enough. We're down to a minute 44. Are there any questions from the, yes?
So what would you recommend people do if at the stage where you know, they allege harassment by a supervisor, and then the employer's process for remedying or responding to that seems to be discriminatory in itself? So like if they tell the accuser or the victim, you know, you take a week paid off while we investigate, meanwhile the harasser gets to stay on and do the thing.
Yeah.
Keep working.
Well, we love it when that happens, and we call it a sham investigation. So that's actually not an uncommon response. So in the Driscoll case that we were talking about earlier, it wasn't a sexual harassment case. It was a retaliation case. But, you know, even in that one, there was a question around the investigation and whether or not it was thorough or fair. And I think one of the reasons why the jury tagged such a large punitive damage award in that case was because we showed the investigation was such a sham investigation. Yep. Yes, sir.
Yes. Earlier you said that even before, as part of the initial vetting, even before you meet with a client, you should determine how many employees the employer has. How can you determine that accurately before discovery? What resources do you use to find that out accurately?
Yeah. Do you want to answer that one, Nicole?
Go ahead.
Okay. So that was your jurisdiction. Well, the thing about the EEOC, it's if you're not always going to know how many employees there are, and so you file the EEOC charge and you wait for the employer to assert that defense. So you're going to count noses with your client and hopefully get close to 15. And then you file your EEOC charge. The good management attorneys, like are sitting right over here, are going to assert that there aren't enough employees. And then at that point, the EEOC will likely ask for the payroll records. And so the EEOC investigator would look at those, and you certainly should ask for access to those. But I guess what I'm saying is, when in doubt, file the charge if it's close. And if you get the news that there weren't enough, well, then there weren't enough. Okay. Yes, sir.
Because the charge of discrimination is so important to the claims you can ultimately bring, what are your thoughts on amending it if a potential employee filed it, didn't necessarily assert everything they should have, the 180 days is now expired? What's been your experience with that, and what's the best course of action?
Just what you said. Yeah, so that's a great point. So once you file your EEOC charge, you have the ability to amend it. So let's say you didn't identify a claim at first, but then you met with your client some more and you identified another box you should have checked. You can file an amended charge, check that box, and I don't think you'll have any problem relating back, to that original charge filing, as long as you're disputing the same termination. And one final trick, and then I got to stop. So after our clients are terminated, that's an adverse action. You're going to challenge it. If your client applies for another job after they've been terminated and they are denied that position, you now have a subsequent claim for failure to hire, and you have another swing at the plate with this employer, especially when you have a job elimination. So I would say in at least half of our cases that are RIFs, our clients apply for another position, and what do? We file an amended charge on the failure to hire too. All right, so we're out of time. And thank you, Nicole. Great job. Thanks, everybody.